Okay, back on the record in the matter of the people of the state of Michigan versus Monay comments. Anything we need to address before we call the jury back in?
Yes, at this time, Your Honor, people just ask for sequestration.
Frustration is granted. They would be your witnesses,
Yeah.
so.
Yeah. Yeah.
Just to sequester them, I don't know, are they in here? It's just one witness in here, or
No, there's two, Your Honor.
you have two witnesses in here? Okay. Who do you intend to call first?
The victim's matter, Makia Thomas.
Okay, so the other witness can be sequestered.
Yes.
Okay, any other matters before we call the jury in?
Nothing more, people, Your Honor.
Thank you, Mr. Lee. Any matters?
No matters, thank you, Your Honor.
Okay. All rise for the jury. Be seated. Everyone's back from lunch, everyone's comfortable. Okay, good. We will begin with opening statements. Mr. Rowitz.
Thank you, Your Honor. Good afternoon again, ladies and gentlemen. Hope everybody had a nice lunch. So we're here today, as you may have already discovered from the instructions and from our opening questions, for a crime of assault and battery. Now, we all have families. You've all had disagreements and arguments with members of our family. I think that's a pretty common thing, especially in today's day and age. Things can get pretty heated around certain topics. However, one thing that should never happen among family is that should never come to blows. Family should never assault family. But that's what we had happen here in this case. The people expect that you will hear evidence, and the people expect that evidence will show that on April 14th of 2020, the victim in this case, Miss Makia Thomas, was having an argument on the phone with her cousins, and that two of her cousins, another cousin and the defendant, Miss Monet Thomas, came over to Miss Makia Thomas's residence. And after she was punched by the one cousin, she was then pepper sprayed in the face by the defendant. After that, the defendant left with Miss Makia Thomas still having that pepper spray. people expect that once you hear this evidence, that you will find that we have met our burden beyond a reasonable doubt, and that we would ask that you come back with a verdict of guilty for the crime of assault and battery. Thank you.
Mr. Lee, you can give the opening statement at this time, or you can wait.
I'll do it at this time. Thank you. Good afternoon, ladies and gentlemen of the jury. Thank you again for being here. This is an assault and battery trial. But it's just like when you were in elementary school and there was a fight and the teacher comes over and breaks it up, and then what does she ask? Who started, right? Who started? That's always the question. Why is that the question? Because if somebody started it, then the other person was justified in reacting, right? So it always comes down to who started. And as the prosecutor said, in this case, we have two different stories. They both involve pepper spray. One person says she pepper sprayed me. The other person says, no, she pepper sprayed me. You can see why we weren't able to resolve this case. So unfortunately now that task falls to you. You have to listen to the evidence and decide who started, who sprayed that pepper spray first, okay? Because whoever sprayed that pepper spray first started, and the other person was justified in reacting. Whatever happened up until that point, words are not enough, okay? Mere presence is not enough, right? If you didn't have just cause for pulling out pepper spray and spraying somebody in the face, that's a problem. Okay? And we believe that the evidence will show that it is in fact the complaining witness who deployed the pepper spray. So we appreciate you being here. We acknowledge your challenge of trying to figure out what happened. And we wish you the best of luck. Thanks.
Mr. Barrows, you can call your first witness.
Thank you, Your Honor. The people would call Makia Thomas.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes.
Okay, you can have a seat there. So there's a microphone that's right in front of you, and directly behind you is my court recorder. She has to take down everything being stated in the courtroom today. So you sound like you have a light voice. I need you to speak loud and clear so that we can pick it up, okay? Also, if there's an objection from either of the attorneys, you would stop speaking. I'm going to give a ruling on that objection, and then I'm going to tell you if you can give that response or not, okay? Then lastly, all of your responses must be verbal. They can't be head nods or shakes because that's difficult to understand in the court record when she's typing it in. And also uhs and ahs don't work. So we need yes or no to yes or no questions, okay?
Okay.
Thank you. State your first and last name, then spell both of them.
Makia, Makhia, Thomas, Thon.
You can proceed, counsel.
Thank you, Your Honor. And apologies, Kai. Ms. Thomas, do you know an individual by the name of Monet Thomas?
I do.
And how do you know Miss Monet Thomas?
We're related to family.
How are you related? If you could elaborate on that.
My grandmother is related to her grandmother, the sister. I guess she's like the second cousin.
Okay. So your grandmothers are your sisters, correct?
Yes.
Okay. And do you see Miss Monet Thomas anywhere here in the courtroom today?
I do.
And can you indicate where she's sitting in an article of clothing she's wearing?
She's sitting in front of me. She has on this blue and white. This sweatshirt.
Okay. And is that, when you say in front of you, is that to your left or right?
All right. My left.
Please let the record reflect the witness has identified the defendant.
Any objection to identification?
No objection to the identification.
Objection is noted.
Okay. And so, Ms. Thomas, do you remember the date of April 14th, 2020?
Yes.
And why do you remember that date?
Because she came to mine.
Okay. So before we get into that, when you say she came to your house, was that a house you own, or was that?
That was my mother's house.
Okay. So you were living with your mother at the time, and if I may ask, how old were you when this incident took place?
I think I was about 17.
Okay. So you stated that Miss Thomas came over to your house that day. What caused her to come over to your house that day?
Her, my mom, not her mom, excuse me. Her mom and my mom had an altercation. My mom ended up going over there. I was present. She ended up telling her kids one story, so they came to my house.
Okay, so when you say your mom went over there, where are you referring to when you say over there?
Her mom's house.
Okay. Are you talking about Miss Thomas's house?
Yes.
Miss Monet Thomas's
Yes,
house?
I
Okay.
guess they went down.
Okay. So did there ever come a time on that date when you were speaking with Miss Monet Thomas on the phone?
Yes, before she came to my house.
Okay, and what were you talking about on the phone with her?
We basically were talking about what was said between them two. It blew up. We got to arguing. You know, it led to her saying she was gonna come to my house.
Okay, and if you remember, do you remember what the argument was about between your respective mothers?
I'm not really sure. We all ended up arguing at her house. So it blew up from there. Like it went from them having a conversation to the all of us like kind of arguing. She then went back and told her daughter that we tried to come to her house and jump her. So that's when she felt the need to come to my house
Okay.
or my mom's house.
And so just for what address was that you were living at this time?
3323 Independence.
Okay, and is that located in the city of Lansing,
It is.
in Ingham County?
Yeah.
Okay.
I just have a quick question. Right before you went into the venue, Ms. Thomas, you stated she then went back and told her daughter that you all came to jump her. Did you hear somebody say that?
Yes, I've heard it being said. It was two different
Who is
stories.
she that you're saying she went back and told?
Her mom,
What's her mom's name?
Tracy.
So you're saying you heard Tracy tell Monet that you all came to jump her?
No, that's not what was said. What
No, what did you hear? Because I don't want you to tell me what you heard someone else said. I want you to tell me what you heard said.
When she called me, that's what she told me her mom said.
Okay, thank you. That's what I wanted to clarify.
Okay, so when you, just to clarify again, when you called Miss Monet Thomas, she informed you that her mother Tracy had told her that you had gone to her house to jump her.
No, she called me,
Okay.
and she proceeded to tell me we came to her house.
Yeah.
To jump her mom.
Okay.
Yes.
Okay. And did you go to her house to do that day?
No,
Oh.
that was, from far as I'm concerned, I didn't even know what was going on when we put up there. They had started having their own conversation.
Okay. So you get into this argument with Miss Thomas on the phone, and then you stated she came to your mother's house, correct?
Yes.
How long were you still on the phone with her when she came to your mother's house, or had you?
No, we were then off the phone.
Okay, and how long had you been off the phone with her?
I'm not sure. Probably about a few minutes. I don't know.
So when Miss Thomas came to your mother's door, was she alone at that time?
No.
Who was with her at that?
Her brother and another guy.
Okay. So she comes to your mother's door. Did they say anything when they came to the door? How did they act when they came to your mother's door?
They were just banging on the door. Her brother went to the back and banged on the door. She was in the front.
And did Miss Thomas say anything while she was banging on the door, or was she just
She was telling
pounding?
us to go outside.
Okay. So at some point, did you open the door?
We did. I think I opened the door. Yeah, I opened the door.
Okay. And what happened after you opened the door?
We started. First, it was her brother because he ran to the front. He hit me, and then I tried to fight him back. Whatever. I tried to fight her. She pepper sprayed me. I went to go get my pepper spray, and I pepper sprayed. I tried to pepper spray back. By that time, I think I probably grazed her or something. She was gone though. Like it was quick. It all happened. Everything was happening at once, kind of.
Okay, so you got into, just to go back and clarify for just a second, you got into an altercation with her brother,
I did.
a physical altercation, and then she pepper sprayed you.
Yes.
Okay. And then you stated that you went in to get your own pepper spray,
I
correct?
did.
Okay, and did you ever hit Miss Thomas with that pepper spray?
I'm not sure. I know I sprayed it for sure though.
Okay. And what happened after that?
It was over. She left.
Okay. And after you were pepper sprayed, how did you feel after that?
I was still mad. I'm still mad.
Okay. Did you suffer any physical injuries because of the pepper spray?
For a minute, like it burns.
Okay. And did you ever contact the police in this incident?
No, I didn't contact them. My mother did.
Okay. No other questions this time, Your Honor.
Cross-examination.
Ms. Thomas, are you aware of this sort of long-standing feud between your mom and Monet's mom? Yeah.
A little bit. Like it's not really my business, so I
Right.
really don't try to feed into it.
What do you think was your mom's reason for taking you with her over to Monet's mom's house?
I was supposed to get dropped off. She said she had to go. She wanted to talk to Tracy or whatever the case may be. The plan wasn't even for me to. I didn't even know I was going over there at the time.
But your mom took you.
Yes.
When Monet contacted you, did she ask for your mom's phone number?
No.
No.
She didn't ask for me.
Now you testified that Monet and her brother were there and that you opened the front door and that you started fighting with Monet's brother. Is that accurate?
Yes, he threw the first punch. Yeah, we started fighting.
You and Monet's brother were fighting.
Yes.
Did you, but you didn't have pepper spray on you then?
No.
You went and got it later?
Yes.
I see. So according to your story, when Miss Thomas pepper sprayed you, was she trying to assist her brother?
I guess so. I guess you can say that.
Okay.
Yes.
Okay. Questions?
I have a question. Ms. Thomas, you testified on your direct examination that when the defendant and family members came to your house, that you opened the door, that the defendant's brother hit you, and that you fought the brother, but then you tried to fight the defendant. At what point did she deploy pepper spray? Was it when you were fighting the brother or when you were trying to fight her?
When I was approaching her, yes.
Oh. Mr. Broderick.
Thank you, Your Honor. Yes, Ms. Thomas, just briefly. So you stated on cross that Ms. Thomas's brother threw the first punch, right?
Yeah.
And did he hit you with that punch?
He did. I want to say that it was more like because my mom was kind of standing in the middle. So when he went to hit me, he didn't hit me where he wanted to, like in my face area. He ended up hitting me on my shoulder and he ended up falling back. So when I got up, we proceeded to still fight, and he punched me again. And then that's when I proceeded to approach Monet.
Okay. And did you ever, can you describe for the jury, give a brief sort of physical description of Ms. Thomas's brother?
I don't know. I haven't seen him so long. I couldn't give you at the time he had short hair It was brown.
When you say now, I guess when you say tall, would you say about my height, taller?
Probably a little bit taller.
Okay, and would you say he's athletically built?
He's normal fit. Not really.
Okay. And then is he older than you, young, or?
He's older. He's not.
Okay. Do you know about how much older he is than you?
No, I do not.
Okay. So then just briefly, you to follow up, you said that you approached Miss Thomas. Did you ever swing at Miss Thomas?
I can't remember. I feel like I think I did. I think I'm the one who approached her, but I ended up being pepper sprayed. You know.
Mm-hmm. No other questions, Your Honor?
May this witness be excused?
Yes, sir.
Okay, ma'am, there is a sequestration order. That means you're not allowed to, ma'am, Ms. Thomas. There's a sequestration order. That means you are not allowed to speak to any other witnesses about your testimony, okay? Give me just a moment. I think we have a question from the jury. Ms. Thomas, how were you able to go inside and get your pepper spray after you were being pepper sprayed? You were able to see and go inside and get pepper spray?
I'm not. I think I had my pepper spray.
Oh,
I had my pepper spray, but it wasn't on me. I had the idea of already having pepper spray. So when in the midst of me blinding my eyes, I knew where my pepper spray was. It's my house. I grabbed my pepper spray.
okay, I'm confused. Did you have it on you or did you not?
I didn't have it on me, but I went to go get it. Like it was nearby. It wasn't that
Okay, so
far.
you were able to see to go and get the pepper spray?
Yeah, sort of. Because by that, when I got pepper sprayed, my mom had already had water. So I was already like, I could see, but I couldn't see. Like I was mad. I really didn't care if I couldn't see.
Okay, any other questions from the jury? Okay, thank you. You may be excused, ma'am. You can call your next witness.
Thank you, Your Honor. The people would call Miss Burnetta Bush.
I will.
Here. You come right up here and I need you to raise your right hand before you sit down. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat there. Okay, there's a couple of rules. There's a microphone that's right in front of you, and the lady behind you is my court recorder, so she has to take down everything that's being stated today. So your responses must be loud and clear. They must be verbal. You can't do head nods, you can't do head shakes, you can't do mm-hs and uh-hs, okay? It has to be yes or no, okay? Then also, if there's an objection from either attorney, you would stop speaking immediately. I'll make a ruling on the objection, then I'll tell you if you can give that response or not, okay?
Yes.
Okay, so could you state your first and last name and spell both of them?
Burnetta, Warnetta, last name Bush, USA.
You could just speak down to them.
Good afternoon, Ms. Bush. Ms. Bush, do you know an individual by the name of Monet Thomas?
Yes,
And how do you know Ms. Thomas?
she is my cousin.
Okay. And do you see Miss Thomas here anywhere in the courtroom?
Yes,
Can you please indicate where she's sitting in the article of clothing she's wearing?
he's sitting over there.
When you say over there, is that your left or right?
No. Alright.
Your left? Okay, and can you describe something she's wearing?
One, blue item.
Please let the record reflect the witness has identified the defendant.
Any objection to ID?
No objection, Your Honor.
Identification is noted.
And Ms. Bush, do you recall the date of April 14th, 2020?
Yes,
And why do you recall that date?
that was the day they came to my house.
Okay, when you say they, who do you mean?
It was her and her brother and another individual,
Sorry, when you say her, can you?
Monet Thomas.
Okay. And what was the address of that residence they came to?
3323 Independence Lane.
All right, is that in the city of Lansing,
Yes,
in Ingham County?
yes,
So you stated they came to your house that day. What, I guess, motivated Ms. Thomas to come to your house that day?
my daughter disrespected their mom. And it was told to them that we was coming to her house to fight her, but I did not come to her house to fight her. So, and I just feel like it was just told in the wrong direction. It was just given in the wrong direction to the kids because they had no idea of what was really going on.
Okay. So Ms. Thomas comes to your house. What does she do when she arrives at your house?
She didn't come to my door. Her brother came to the door,
Okay.
and they came there to fight my daughter.
When you say they came there to fight your daughter, how do you know that?
They were banging all on my door, and it's the way that they were acting.
Okay. At some point, was the door open?
Yes,
Okay. And what happened after the front door was open? Well, sorry, let me back up. Who opened the front door?
at that time, I had a boyfriend there. His name was Dre. He opened the door, and when he opened the door, my daughter was standing, I believe, behind him.
Okay.
And as I can remember, her brother charged in at my daughter because it broke my closet door. And when it broke my closet, when she charged in at my daughter, then my daughter went outside after that.
Okay. So when you say, let's back up for a minute. When you say he, are you referring to Miss Thomas's brother?
Yes,
Okay. And when you say charged in, can you just describe that a little bit for the jury, what you mean by that?
just kind of went in after him. Just kind of rushed into the front door after him.
Okay. And did he make any movement to strike your daughter? Did he hit your daughter in any way?
Yes,
Okay. Where did he hit her?
I believe she was hit like in the chest. I believe she said probably in the face, I think.
Okay.
Objection, Your Honor. The defendant said that she's quoting what Makia said. Is this her actual, did she see it? Because she just said.
You said are you talking about the witness?
The witness said that Makia said that's how it happened. So is she reporting what Makia said, or is she reporting what she saw?
Okay, ma'am, is this what you saw?
Yeah,
Okay.
Okay.
Objection overruled.
When Miss Thomas's brother charged into your house, where were you standing in relation to Makia and your boyfriend at the time in the front door?
I was right there in the front door. I
Okay.
was trying to stop him from coming into my house.
Okay. So you stated at some point that Makia then ended up outside after Miss Thomas's brother charged into your house,
Like
correct?
right on the front porch part. She ended up.
Okay. And did she engage in a physical altercation with either Miss Thomas or her brother?
When she stepped out on the porch, Monet then sprayed her in the face with mace. So then when she got sprayed in the face with mace, it just started to just like really burn her face. So the only thing she could do, she was just screaming out and crying. So at that time, I just tried to comfort my daughter and tried to get some water and tried to help her.
Okay, so backing up just a little bit. So before Miss Thomas sprayed your daughter in the face with pepper spray, did your daughter ever strike her, swing at her, anything like that?
No,
Okay. So after you said you got some water for your daughter, did she ever grab pepper spray of her own?
no,
Okay.
we didn't have pepper spray.
Okay. And then after your daughter is sprayed in the face with pepper spray, what happens after that? So let me clarify that just a little bit. Sorry. So she sprayed in the face with pepper spray. You said you were getting her water, I'm assuming, to try and get that off. What happens after that?
Nothing happened after that. She went to the sink trying to get her, because when you get sprayed with pepper spray, it hurt, it's burning. So she's going to the sink trying to get her face back right, I guess. And then they jumped in the car and they left after that.
And did you ever contact the police in this matter?
Yes, I did.
All right. And how quickly did the police respond to this?
I believe it was like 30 to 45 minutes before they even came.
Okay. And again, just briefly, I think you kind of got into it, but after your daughter was sprayed with the pepper spray, can you describe kind of her demeanor and what she did after that?
After she was sprayed?
Yes.
It was burning, so she was trying to get to somewhere to get water for her face.
Okay. No other questions this time, Your Honor.
Prosecutor. I think Ms. Donnelly wants your attention.
Thank you, Ms. Bush, for being here today. You testified that you and your daughter went over to Monet Thomas's mother's house. Her name's Tracy Young, right?
Yeah.
Okay, but you didn't go there to fight.
No,
Okay. Do you ever take your daughter places to fight? Do you ever drive her to fights?
no,
You also testified that your boyfriend opened the door, not Makia.
correct.
Gotcha. And you also testified you don't have any pepper spray in your home.
No, I don't.
Do you believe that this whole incident has basically sprung up from your feud with Miss Young, or Miss Young's feud with you, between you guys' disagreement?
Her feud with me?
Yeah.
Yes.
Okay. All right. And so when this incident occurred, the police report reflects that there was an interview conducted about 3 days later. When did you call the police?
I called the police the same day.
Okay. That's not bad manners, it's good food. So, so you didn't wait, you made the report that same day.
Yeah.
And it's your testimony that the brother, that is Monet Thomas's brother, charged into the house as soon as the door was open.
Yeah.
Okay. It is also your testimony that Makia got sprayed as soon as she stepped out on the porch.
Yeah.
Gotcha. And where were you standing when the fight was going on between the brother and your boyfriend and Makia and Monet? Where were you standing?
There wasn't a fight with my boyfriend. It was just basically her brother and my daughter, and right inside my house fight. He hit my daughter.
And where were you?
I was like I was inside the house, like right there where they were fighting.
So they were right next to you. You could see it the whole time.
Yeah.
Gotcha. do you think that Monet and her brother, you testified, I'm sorry, that they must have showed up to your house to fight, right?
Yeah,
But when you went to their house, that wasn't to fight, that was just to have a talk, right?
yes.
Ms. Bush, if your story is different than Makia's story, whose story should we believe?
No, so I should believe.
Yeah, I don't know. No further questions.
Thank you. I just have a quick question. You testify you were inside the house when the incident occurred between your daughter and Miss Monet's brother?
Yes, I was inside the house.
Okay, did you ever go outside?
I never went outside. I stood right inside the house.
Okay, who was outside the house?
Makia stepped outside the house.
No, who was outside when she stepped outside?
It was Monet and her brother, and they had another individual with them on the sidewalk.
It's the same brother that Monet, I'm sorry, that Makia was fighting with?
Yes.
Okay, so he then went outside, is that what happened?
Yeah, he went outside after the fight, and then my daughter went outside, and that's when
Okay.
she got pepper sprayed.
Okay, do you know why your daughter went outside? Did you
I-
see what she did when she went outside, or were you inside the house?
I know she went outside and she kind of stood there and was yelling. She was yelling. That's all I remember.
Did you go outside too?
No, I didn't go outside. I stood right
Okay, so
inside
then
the
you
door.
couldn't see what's outside, correct?
No, I don't have a screen door or anything. My door is just like one open door.
One door, no
Yeah,
screen.
there's no screen or nothing.
But are you able to see from the inside what was happening outside?
Yes, I was.
Okay, you were able to see?
Mhm.
Okay, that's a yes?
Yes.
Okay, any questions from the jury? Direct.
Just briefly, Your Honor. So I think just to clarify a little bit, sort of what the judge was asking, when your daughter went outside onto the front porch, you were standing in the doorway of your house?
Yes.
Okay, so you could see outside, but you weren't physically outside.
Yes.
Okay, and just ask again, before your daughter was pepper sprayed, did she ever make any sort of advance towards Miss Thomas, or did she ever come into, did she ever swing at Miss Thomas? Did she ever attempt to hit
No.
Miss Thomas?
They didn't get a chance to fight. She sprayed with pepper spray in her face.
Okay. No other questions, Your Honor.
Any questions from the jury? Okay, you may be excused. I'm gonna advise you that there is a sequestration order, so you're not to discuss any portions of your testimony with any other witnesses, okay? That
Okay.
includes your daughter, okay?
Okay.
Thank you. You can place them, or place her outside. Any other witnesses?
People have no other witnesses at this time, Your Honor. People were dressed.
Okay, we're gonna take a brief recess. You're not free to deliberate at this time. We're gonna address some other issues. I have some other people I need to arraign. And then we'll call you back in and see if we are gonna proceed with the defense proofs at that time. But again, this is not the time to deliberate, okay?
How long?
I'm sorry? I can tell you how long. It's probably gonna be at least 15 minutes because I need to arraign a couple of people. Give me just a moment, ma'am. I need to arraign a couple of people, but we'll have somebody bring you some water and some snacks. You have a question?
Can I go downstairs and smoke or not?
You have time.
Okay,
Thank you. All rise for the jury.
go ahead.
How
Sorry.
are you?
Oh, sorry, I'm in the hurry.
Good.
Sorry.
Drew Aldrich. Okay, on the record in the matter of the people of the state of Michigan versus Drew Aldrich, file number is 22-03313. Mr. Aldrich states the date and time set for an arraignment on a probation violation. I do have a request and summons for a probation violation here. It alleges that you violated your probation by committing the following technical violations. It says you failed to appear for your domestic violence counseling session on July 18th, July 25th, and August 1st, and failed to appear for your MRT sessions on July 20th and July 26th, 2023, in violation of your probation status. So you have the right to have a contested hearing. You have the right to be represented by an attorney at that hearing. If the court determines that you were in violation of your probation status, your probation can be revoked or it can be extended. You can be sentenced to a term of jail time for the violation, or you can face increased sanctions or oversight as part of your probation status. You understand your rights as it relates to the violation process?
Yes, sir.
Did you want to request an attorney to represent you?
I don't believe I need one, Your Honor.
You do not believe you want to request an attorney, or how do you want to plead? You want to plead guilty or not guilty?
Guilty, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do, Your Honor.
Thank you. And you understood the rights that I just advised you of?
Yes, ma'am.
You're willing to waive your right to be represented by an attorney in order to plead guilty to the violations?
Yes, sir.
Has anybody made any promises to you to get you to waive your rights and plead guilty? Anybody threatening you to get you to waive your right and plead guilty?
No.
Okay, and you're pleading guilty to the violation because you believe you're guilty? Okay, as to the violation that you failed to appear for domestic violence counseling sessions back on July 18th, July 25th, and August 1st, how do you plead?
Guilty, Your Honor.
And as to the violation that you failed to appear for MRT sessions on July 20th and July 26th, how do you plead?
Guilty, Your Honor.
Okay, and so as part of your probation status, did I order you to participate in counseling for domestic violence?
You did, Your Honor.
Okay, and did I also order you to participate in more recognition training?
Yes, sir.
Okay, and did you miss those trainings and those sessions on the dates that I just spoke of?
I did, Your Honor.
Why is that?
I was in the process of moving. We had been evicted. I wasn't allowed to be at the residence due to the no contact order. And so I wasn't able to continue to help pay the rent and everything like that. So we had to move. I wasn't able to go there to get any of my things. And by the time I moved, I didn't have any internet. My phone bill was due. Just everything piled up all at once. I have since re-enrolled in my classes. I'm back doing my classes again.
So your phone was cut off, sir?
Yes,
Okay, and it's now back on?
yes,
Okay. And so you're now re-enrolled?
yes, ma'am.
You've been participating in all your sessions?
Yes, ma'am.
As well as your MRT? Okay, so I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. I am going to continue your probation at this time. I'm going to admonish you that I do recognize that there was some transition that you have undergone. You're still required, however, sir, to participate and report to all of your sessions. And even if that means you got to go to a library or borrow someone's phone, you got to make sure you're doing what you're supposed to do, because you said that you would be responsible at the time of the sentencing for your probation requirements, okay?
Yes, sir.
Okay, so I'll continue your probation at this time, and hopefully you won't have any other violations. I don't see that there's been any issues since the time that I signed this, where it looks like Judge Ward signed it on my behalf, this violation. So do you have any questions at this time?
No, ma'am.
Okay, you're all set. Thank you.
Thank you.
Sabrina Bartel failed to appear.
Yes.
Big warrant. And once number 6 returns from her cigarette break, we'll be ready to roll. back on the record. Any matters before we call the jury?
Nothing from the people, Your Honor.
Your Honor, the defense would make a motion for a directed verdict. We believe that the prosecutor has failed to meet the elements of the crime. The complaining witness admits that she approached the defendant. Complaining witness admits she may have thrown the first punch. The complaining witness admits that the defendant deployed pepper spray to protect herself from her approaching. And the cooperating witness gave completely contradictory statements. So we ask the bench to consider a directed verdict for the defense.
Okay, the basis of your motion was again because the complaining witness admitted approaching the defendant prior to being pepper sprayed, and then that she being the complaining witness may have thrown the first punch. And then what was the third basis?
She said that it was her belief that the defendant deployed the pepper spray because she was approaching her, which would make that self-defense.
Thank you. Mr. Brodowitz.
Yes, Your Honor, the people would ask that you deny the motion for a directed verdict. As the law is, it's the facts and evidence are to be taken in the light most favorable to the non-moving party. In here, we have testimony from the complaining witness stating that she was, when the two individuals came over to her house, she was assaulted first, which I believe would, negate sort of any self-defense argument. But beyond that, we
Her
have
testimony was that she was assaulted first by the defendant's brother, who's not here on stand. She did not testify that she was assaulted first by
but we also have,
she did not testify that she was assaulted first by Ms. Monet Thomas. She stated 3 times at minimum, from my recollection, that she approached Ms. Thomas, and as she approached, she was pepper sprayed. So how would that negate a self-defense?
however, I guess it wouldn't necessarily negate a self-defense. However, we do have testimony from the other witness, Ms. Burnetta Bush, that where she testified that the complaining witness in this matter, Makia Thomas, was not approaching Ms. Thomas when she was pepper sprayed and was just outside on the step when she was pepper sprayed.
So your suggestion is that we should listen to the testimony of the mother who says she was inside versus the witness herself?
I believe the testimony of the mother was that she was in the doorway, but could see outside of what was happening as she was standing directly in the doorway, staring out at what was happening, Your Honor.
So what you're saying is if I said something happened to me and Ms. Nash was watching, you should believe what Mr. Nash said happened to me versus what I said happened to me. That's what you're saying?
I'm saying, Your Honor, I believe it raises a question of fact for the jury.
As to whether or not the complaining witness's story was accurate?
Yes, as to whose credibility they would assess to be more credible, either the mother's or the complaining witness in this matter.
Okay, and as to meeting the elements, because the testimony was that you provided insufficient evidence to meet the elements.
Well, I believe, Your Honor, by being pepper sprayed in the face, pepper spray would be considered an assault or assault and battery, as it would be a harmful or offensive touching that would be against Miss Makia Thomas as well.
Okay, and what about a self-defense? Because you would have to prove, if they're asserting a defense of self-defense, that it's your duty to prove beyond a reasonable doubt that she did not act in self-defense.
Well, again, Your Honor, I would go back to the testimony of the difference in the testimonies and argue that that would be a question of fact for the jury to decide, Your Honor.
Well, I'm talking, you need to tell me what evidence did you put forth that supports that she did not act in self-defense. I'm not following which evidence you're saying.
I had the testimony of Miss Burnetta Bush, who stated that as she was watching this incident unfold, that her daughter never approached and never made any sort of aggressive movement towards the defendant, Miss Thomas.
Did she say aggressive movement, or that's your interpretation?
I asked on cross-examination if there was any sort of physical altercation, or if there was any sort of aggressive, may not have been the exact word I used, Your Honor.
You never even mentioned the word aggressive, so we can't interpret what you wanted to say. You asked if she ever approached or if they had altercations, what you asked. And and you didn't ask anything about any aggressive movements. So
However, Your Honor, I believe even with that, there was no altercation between the two. So again, I believe that would raise a question of fact for the jury as to whether this was actually done in self-defense or not, based on whose testimony they find more credible.
okay, any re-argument?
Your Honor, I think the basis for any criminal complaint is the allegations put forward by the complaining witness. And in this case, the complaining witness quite plainly and clearly says she approached the defendant. She even at one point said, I may have thrown the first punch. Now, her mother says she went out onto the front porch. One could interpret just as well somebody going out onto the front porch as being looking for further engagement. Otherwise, why would you go out on the front porch? So I think that either way, it suggests that the complaining witness is shown via the testimony here today that she was willing to engage and did in fact engage the defendant, Miss Monet Thomas, who according to the complaining witness's own story, acted in self-defense.
I'm going to reserve my decision and we'll proceed with the trial. I'll make a ruling at the conclusion of the trial. Thank you. Are you going to call any witnesses?
Ms. Mitchell. That is your choice.
Okay, we're back on the record. Mr. Lee, are you gonna be calling any witnesses?
Yes, Your Honor, we're going to call Monet Thomas to the stand.
Okay, we can call the jury back. Did you want to voir dire your client outside of the juries? Okay, Ms. Thomas, raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. You can have a seat. Counsel, you can voir dire your client.
Thank you, Your Honor. Ms. Thomas, you understand that as a defendant in this trial, you have the right to stand mute and or not testify. You understand that nobody can use your silence in this trial against you.
Yes.
And it's still your decision that you want to take a stand and provide testimony.
Yes.
Thank you.
Thank you. All rise for the jury. Okay, you can be seated. Okay, Mr. Lee, you can call your witness.
Thank you, Your Honor. Defense calls Monet Thomas.
Can you take the stand? And Ms. Thomas, I did just swear you in before the jury was admitted. And you've already heard the rules. We need yes or no's, no mm-hms and uh-huhs, and no head shakes and head nods, okay? Thank you, counsel. You can proceed.
Thank you, Your Honor. Ms. Thomas, you have heard all the testimony up to this point, so you know what we're talking about. On the day in question, what prompted you to go to Makia and Miss Bush's house?
My mother had called me and she had told me that Makia and her mother Burnetta had went to her house.
Your Honor, at this point, I would object to hearsay.
I'm gonna overrule it. They've already testified to this.
They had went to her house and they tried to fight her. My mom had called me and I was with my brother and my other friend. So I text Makia on Facebook. I never called Makia. I text her and I asked her, like, what's going on? Like, what's your mom's number? Because I heard that y'all was coming over my mom's house. So she never gave me her mom's phone number. So I go over there. By the time I even get there, my brother's in front of me. I'm behind my brother. Before we even get on the doorstep, Makia opens the door. It's Makia's mom on the left side, then it's Makia in the middle, and then Makia's mother's boyfriend. We're standing in the doorway. I'm asking her, why did you guys go to my mom's house trying to fight? Like, what's the issue going on? They're trying to argue back and forth with me about the situation. And then at that point, Makia goes into her pocket. She has her hands in her pocket. She had a basketball shirt at the time. She pulls out a black thing of mace out of her pocket. And my brother said, what are you going to do with that? And at that time, that's when she started to spray my brother. My brother had his head down. He tackled Makia into the closet door, which caused that closet door to break. At that point, I grabbed my brother off of her. I got him in the car. I had water in the car. I started flushing my brother's eyes out with the water that I had in the vehicle. And at that point, after he was like almost clear, then we had left.
I see. So did you and Makia have a fight?
Me and Makia never had a fight. Never physically had a fight at all. We only had exchange of words.
I see. And so no further questions.
Cross-exam.
Yes, thank you, Your Honor. Good afternoon, Ms. Thomas. So, Ms. Thomas, you stated that why did you go over to Makia's house on the day in question?
Because my mother had called me and said that they were trying to fight my mother. They were trying to jump on my mother. And this has been an ongoing feud for years.
Okay, but why, what was your intention going over to the house?
I went over there to talk to Makia's mother. I never even went over there to talk to Makia. That's why I texted Makia on Facebook asking for her mother's phone.
So when you arrived at the house, it's your testimony here today that you and your brother just went up to the front door and they opened the front door.
Before we even got to the grass, they were standing in the doorway.
So you and your brother never pounded on the door?
They never
whenever you-
pounded on the door.
Okay. And then it's also your testimony here today that you never once pulled out pepper spray during this.
I never had pepper spray. I had a pepper spray keychain, but I never pulled it out to mace Makia. Makia had put her mace out and then she maced my brother. She didn't even mace me. And she didn't try to fight me either.
Okay. So this all resulted from an ongoing feud between your mothers, correct?
Yep, yes.
So what caused you to feel you needed to get involved in this?
Just because it's my mom, I feel like I need to protect my family. I love my mom, and it was just too much. It was stressful. It was getting out of hand. Years on top of years. It just needed to end. And I was trying to be like a mediator, kind of, in a way. I went over there to talk to her, and they took it the opposite way.
And so again, it's I don't think that is, but it's your testimony then that without provocation, Makia just pulled out pepper spray and started to spray your
Her and
brother.
my brother were going back and forth arguing. They were arguing in the doorway of their home. She had pepper spray in her hand. My brother said, "What are you gonna do with that?" And then he had called her a name. Then that's when she started to spray my brother. And that's when my brother tackled Makia into the closet door so he wouldn't continue to get pepper spray in his face.
No other questions, Your Honor.
Redirect.
Yeah. When your brother and Makia were in the doorway arguing with each other, did you see Makia pull the pepper spray out of her pocket?
I did. Me and my brother both saw it, and that's what made him ask her, "What are you gonna do with it?"
No further questions, Your Honor.
Any questions from the jury? You can write it down, ma'am. Okay. Did your cousin and your aunt know that you were coming over to the house, or how did they know to open the door?
I had talked to Makia previously, like when I text her on Facebook, I said, "What is your mom's phone number?" And she I'm trying to think, like, it was so long ago. I don't know if I text her and then we had talked on Facebook, but some way, somehow, it was either me or my brother, but I know I didn't tell her I was coming. Maybe my brother had called her and said, like, "We're about to pull up, we're about to pull up." I think he was the one calling her. By the time we even got there, like I said, she opened the door, like she was expecting us to come.
Okay. Any other questions from the jury? Okay, may this witness be excused from the stand?
Yes, Your Honor.
Okay, thank you, Ms. Thomas.
No problem.
Any other witnesses for the defense?
No other witnesses. Thank you, Your Honor.
Thank you. Will there be any rebuttal witnesses?
No rebuttal witnesses, Your Honor.
Okay, very good. So we're going to take a break so we can prepare our final jury instructions. And the jury needs to see Treasury, I believe. Then maybe administration will bring them some snacks if they haven't done that. Okay, sounds good. So we're gonna recess for that time period. It'll probably be about 15 minutes. You gotta run downstairs and get your payment for today. All right. Again, you're not free to deliberate at this time. Thank you. All rise for the jury. Okay, very good. You can be seated. Proceed with closing arguments, Mr. Brodowitz.
Thank you, Your Honor. Again, ladies and gentlemen of the jury, thank you for bearing with us. I know it was a long morning. Realize this wasn't our longest jury trial, but thank you for bearing with us anyways. So I started off by saying that, this started out as an altercation between family members, but altercations like that shouldn't come to blows. And when you go back and deliberate, I would urge you to look at the testimony that we heard and to judge the credibility based on the testimony that you heard. I would urge you to look at the testimony of both Ms. Bush and Ms. Thomas. Yes, there were some differences in in their testimonies, but this incident happened 3 years ago. Everybody's memory is different, even minutes after something happens, let alone 3 years. So I'd ask you to hold that into account as well. But then I would urge you again to look at their testimonies and see the similarities between the two of them. Both of them testified that the defendant, Ms. Thomas, and her brother came over to their house, were pounding on doors, and that when the door was open, that Ms. Thomas's brother assaulted the victim here, my apologies, the victim here, Miss Makia Thomas, and that Makia Thomas ended up outside of the house, and then she was pepper sprayed by Miss Monet Thomas here. Largely, the stories that they tell are the same. Yes, as I admitted, there are some differences, but that's a completely different story than what you heard from the defendant. If you listen to the defendant's story, because she heard of a alleged altercation between her mother and Makia's mother, she decided to drive to Makia's house. But she wasn't there to do anything. She was just there to be peacemaker. Yet, somehow, before they even really got onto the grass, I believe is what she said, Makia, her mother, and her mother's boyfriend were all standing in the doorway with the door already open. But she couldn't tell you how they knew they were coming. She claims she never even talked to Makia that day. Yet we heard testimony from both Makia and her mother that there was an argument on the phone between Miss Monet Thomas and Miss Makia Thomas. Miss Monet Thomas also said that there was never any altercation between her and Makia. It was all between her brother and essentially her brother and Makia. Yet she would like you to believe in her version of events that her brother tackled a roughly 17-year-old girl in front of her mother and her mother's boyfriend, but that after he did that, she just was able to get her brother up and they walked back to the car and they left and nothing happened. When you go back to deliberate, ladies and gentlemen, I would urge you to look at both versions of events that you heard here today. One from the witnesses, Miss Bush and Miss Makia Thomas was largely consistent with some minor differences, whereas the testimony from the defendant was completely different than what you heard here today. I would urge you that when you go back and deliberate and put to your mind if it is reasonable, or which version of events, which story is reasonable, I would ask you to find, and I believe the only be to find, that beyond a reasonable doubt that Miss Monet Thomas committed an assault and battery on Miss Makia Thomas when she maced her during this altercation. And I would ask you then to find the verdict of guilt. Thank you.
Mr. Wood.
Thank you, Your Honor. Ladies and gentlemen of the jury, I told you when we first started that we were going to try to answer one simple question: who started? These simple questions don't always have simple answers. You heard the testimony of the complaining witness, the person who says they were assaulted. The complaining witness said that she opened the door, that she fought with Miss Thomas's brother, and that then she went after Miss Thomas. The complaining witness says that not only did she approach Miss Thomas, but that she may have thrown the first punch. She definitely said that Miss Thomas pepper sprayed her in response to her approaching her. So if you believe the complaining witness's story, then what you know is that Miss Thomas acted in self-defense, right? If you believe Miss Thomas's story, then what you know is that the complaining witness pepper sprayed her brother. Both of those equal not guilty. Neither of those equate to an assault and battery charge. This is a case about a feud between their mothers. That's what this is. That's why it was the mother that called the police, because it was the mother who wanted to find a way to press charges against Monet, because it's a mother that has a feud with Monet's mother. And the mother's testimony was just completely contradictory to the complaining witness's testimony, right? The complaining witness said, I opened the door. The mother said, oh, no, my boyfriend opened the door. The complaining witness said that she pepper sprayed, or that, after she got pepper sprayed, she went back in the house and got pepper spray and came back out to use some herself. Mom said, no, we don't even own pepper spray. Those can't both be right. They cannot both be telling the truth. Somebody's not telling the truth. And what I would say to you is, you've got to choose. Is it the complaining witness you're going to believe, or is it the defendant you're going to believe? Because if you believe either one of those, it's not guilty. I don't believe a word the mom said. I'm sorry, I just don't believe a word the mom said. I think she would have came in here and said anything to protect her daughter, and I think the story she told was outlandish. But even she admitted that her daughter went out onto the porch to approach. She wasn't just a victim. So I think you have a lot to think about. I think you've got some contradictory stories here. But I think the two stories you heard from both the complaining witness and the defendant both equal not guilty. So I don't see how you have a choice but to come back with that. I appreciate your time and your deliberation. Thank you.
Okay, ladies and gentlemen, we need you to fix your attention back to the screens for some final instructions. Okay, members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath, excuse me, to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. Excuse me. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you. The lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt, growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my question to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 14, 2020, within the city of Lansing, Ingham County, state of Michigan. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as the jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your own honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my court officer. It is not proper for you to talk directly with the judges, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any of the reference documents or exhibits that were admitted, just ask for them. There were no exhibits admitted. When you go to the jury room, you will be given a written copy of the jury instructions that you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see that it is raining, that is direct evidence that it's raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence that is evidence that normally or reasonably leads to other facts. So taking the same example, if you see a person come in from outside wearing a raincoat that's covered in small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. I don't believe we had any stipulated facts. However, when the lawyers agree on a fact or a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. I don't think we had any stipulated facts, though. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that she meant to do so. The defendant's intent may be proved by what she said, what she did, how she did it, or by any other facts and circumstances that are in evidence. You should not decide the case based on which side presented more witnesses. Instead, you should think about what each witness and each piece of evidence, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. We didn't have an officer testimony. We'll skip that. Okay, you can pull those two, please. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon a Makia Thomas. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Makia Thomas's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Makia Thomas or to make Makia Thomas reasonably fear an immediate battery. The defendant claims she acted in lawful self-defense. A person has the right to use force to defend herself under certain circumstances. If a person acts in lawful self-defense, her actions are justified and she is not guilty of assault and battery. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to her at the time she acted. First, when she acted, the defendant must have honestly and reasonably believed that she had to use force to protect herself from the imminent unlawful use of force by another. If her belief was honest and reasonable, she could act at once to defend herself, even if it turns out later that she was wrong about how much danger she was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect herself from danger. The defendant must have used the kind of force that was appropriate to the attack made in the circumstances as she saw them. When you decide whether the force used was what was necessary, you should consider whether the defendant knew about any other ways of protecting herself, but you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent her from claiming self-defense if she was attacked. The defendant does not have to prove that she acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. That concludes our jury instructions. You will get a copy of my full instructions to take with you. You should take your notes with you. When you are in the jury room, you need to first pick a foreperson, and then you can begin to make your deliberations. I'm going to release you into the custody and care of my court officer. Please raise your right hand, Mr. Bigelow. Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise until the time that a verdict has been rendered, so help you God. Thank you. All rise for the jury. Oh, all 7 of you don't have to go. Wait a minute, somebody gets to go home. One of you was the alternate. Juror number 6, you're free to go. Thank you.
There you go, ma'am.
Oh, you can give that to him. Thank you. Okay, we are in recess until the time that a verdict is rendered, or if they have a question, so don't go far. Okay, you can be seated. Okay, my understanding is that you do have a verdict. This might be a record, but nonetheless, who's the foreperson? Okay, can you please read your verdict?
We have found the defendant not guilty.
Did you want the jury polled?
No, thank you.
Okay, well, ladies and gentlemen of the jury, I really appreciate your service and your patience. You came back on time every time, you were attentive, you asked good questions, and you've helped the justice system be fulfilled today. And so with that being stated, we're gonna excuse you for the end of the day. You are free to stay behind if you wanted to speak with any of the attorneys. Sometimes they have questions, but you have no obligation to stay for that. You're free to go, and thank you again for service today. All rise for the jury. Okay, you can be seated. Okay, an acquittal, not guilty by way of jury trial will be entered today, and this case will be resolved. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense, Your Honor.
Thank you, and congratulations to you.
Thank you, ma'am.
Thank you. You want to stick around if you want a copy of your acquittal?
I do, yes, sir.
Okay.